Okay, time to go to the next case, which I assume is a case which is close to your heart. I know it's close to somebody's heart here. You also have to make a disclosure. No, okay. India solar cells. Complete title of the case: India, certain measures relating to solar cell and solar modules. Complainant, United States. Respondent, India. Again, 13 third parties, including the European Union, Brazil, China, and many others. Timeline of this case. And again, it's useful to see that. Why do I focus on these timelines? Because you have to see these cases also in a sequence. This is a case that comes after the Canada renewable energy case. The request for consultation in this case was from February 2013. The panel was established in May 2014. The report was circulated in February 2016. Again, can't help but pointing out that the panel went way beyond the 9 months that they are entitled to have for dealing with a case. Although the difference between what the rules under which the panel works and the appellate body works, for the panel, it says that proceedings should not exceed 9 months. Appellate body, they shall not exceed 90 days. Should. The appellate body report came out in September 2016. That's beyond the 90 days, but it's still within the same year. Report was adopted by the DSB on the 14th of October 2016. The measures at issue. Measures at issue, or here I can say it in the singular, the measure at issue was a domestic content requirement for solar cells and solar modules used to generate solar power, and that domestic content requirement was imposed on solar power developers selling electricity to the government, to the Indian government. All that in the context of the India National Solar Mission. So we're looking here again at a domestic content requirement. Now the claims of the United States, the claims of inconsistency, were that this is in violation with Article 3, Paragraph 4 of the GATT, so the National Treatment Obligation. And linked to that, to one of the TRIMS agreements. And you're familiar with both these provisions already, so I can go a little bit fast here. I already, but we have some new participants in the audience, so let me briefly repeat what I already said before. Article 2.1 of the Trade-Related Investment Measures Agreement states that no member shall apply any trade-related investment measure that is inconsistent with the provisions of Article 3. Question is the provision inconsistent with Article 3? If it is, it's inconsistent with Article 2.1 of the TRIPS agreement. Okay. So the other relevant article, of course, is Article 3, and in particular Article 3.4. Article 3.4 tells us that imported products shall be accorded treatment no less favorable than that accorded to like domestic product. But, as we have discussed in the previous case, there is this Article 3.8a of the GATT, which exempts measures from the national treatment obligation of Article 3.4. So if a measure falls within the scope of application of Article 3.8a, Article 3.4, the national treatment obligation does not apply. And to what sort of measures does Article 3.8a apply? Well, it applies to laws, regulations, and requirements governing the procurement by governmental agencies of products purchased for governmental purposes. And purchased for governmental purposes and not with the view of commercial resale. What is new in this case, this is why I have it on my list, not only because it involves India, but also because this is a new element. India invoked in defense of a possible violation, defense of the alleged violation of Article 3.4, it invoked, in addition to the exemption in Article 3.8a, it invoked Article 20 of the GATT, which, as you all know, is the general exceptions provision. It invokes in particular Article 20d and Article 20j from Japan. But before going to these provisions, these paragraphs, D and J, I want to confront you with the chapeau of Article 20. The chapeau of Article 20 says, and subject to the requirement that such measures are not applied in a manner that constitutes arbitrary or unjustifiable discrimination, nothing in the agreement shall prevent the adoption and enforcement of measures, and then only you come to the chapeau. Sorry, then you only come to the A or J. What's important here is that shall not be applied in a manner that constitutes arbitrary or unjustifiable discrimination. So the measure shall not be applied in such a way. Now, keep that in mind. What measures are we talking about? We're talking about, first of all, measures necessary to ensure compliance with laws, regulations, which are not inconsistent with the provisions of this agreement. And we're talking about measures essential to the acquisition or distribution of products which are of general or short local supply. And it is Article 20, 20d, and 20j that were invoked by India in its defense. Should the panel decide that there is a violation of Article 3.4, India falls back on Article 20. What did the panel find? Well, first of all, with regard to the government procurement exemption, the panel found that this exemption was not applicable because the product procured by the government, electricity, is not in a competitive relationship with the product discriminators. Solar cells, solar panels. And that falls back on what the appellate body had ruled in the Canada Renewable Energy case. And we had already a short exchange on this. So the Canadian and then later the Indian, a more sophisticated argument than the Canadians actually made on the interpretation of the scope of application of Article 3.8a was rejected by the appellate body. Because the appellate body focused on the fact that Article 3.8a was an exemption a non-discrimination obligation, Article 3.4, and therefore it was important that there was a competitive relationship between the product discriminated against, and that is the solar cells and solar panels, and the product that was purchased, the electricity. And that competitive relationship was not there. So Article 3.8a was out. Not exempt measure at issue public procurement, did not exempt the measure at issue, the domestic content requirement, from the application of Article 3.4. And then the panel looked at Article 2.1 of the TRIMS agreement, which provides for a national treatment obligation, and it had the following reasoning. And if you go to the TRIMS agreement, you will indeed find that the TRIMS agreement states in Article 2.2 of the TRIMS agreement. Actually, they refer to the illustrative list that is in the annex. And the panel found that the measure at issue here, namely a domestic content requirement, is listed in that list. And that list, the measures listed in that list are considered to be inconsistent with Article 3.4 and with Article GATT and Article 2.1 TRIMS. So that was the reasoning of the panel. But look at the annex. In the annex, you have that measure listed, and therefore we have a violation of Article 2.1 of the TRIMS agreement. I'm not spending too much time on this because it will not be that important later. And since and then in parallel, the panel apparently was not too certain, I think, of its reasoning. They adopted also a whole reasoning on the consistency with Article 3.4. And it came to the conclusion that this measure was inconsistent with Article 3.4, which was very difficult not to come to that conclusion. The defense, very difficult not to come to that conclusion. In defense, India had invoked two paragraphs of Article 20. And I'll start with Article 20J. And in that context, India had argued that the lack of domestic manufacturing capacity and the risk of disruption in imports that actually constituted a situation of short supply as referred to in that paragraph. There are two elements. The lack of domestic manufacturing capacity and also the risk of disruption in imports. The uncertainty that you would find on the international market, the solar panels that you would need for domestic use, and the prices at which you would find them. For India, that constituted a situation of short supply. The panel disagreed. The panel said, no, that is not a situation of short supply. And they first focused on this idea of the lack of domestic production capacity. And with regard to that, they say that products in general or local short supply refer to a situation where the quantity of available supply from all sources, that includes imports, does not meet demand. So you only have a situation of short supply when the supply from all sources, including imports, not suffice to meet your domestic demand. And then it also said that products in general are local short supply. That concept does not cover products at risk of becoming in short supply. And that's a reference to the instability of imports, the danger of relying on imports. And said, well, no, products in short supply are not products at risk, I should underline, at risk of becoming in short supply. Because India was not arguing that it could not possibly fund now, today, that it could not fund, today in the sense of when the case happened, that it could not find these solar cells on the international market. We're not arguing that. We're arguing, hey, we don't have the domestic production capacity, and we don't really want to rely on imports because imports are not reliable. If they could have shown that at that moment imports were not available, then the case would have turned out differently, but they didn't show that. So India did not show the existence of short supply. And actually the panel added, or an imminent risk of short supply. That's already sort of a concession that the panel made. As you will see, the appellate body will go further in going to accommodate the position of India. That's for a moment. So now, with regard to Article 20D of the GATT, Article 20D is not an easy provision to understand. Article 20A is public models, measures necessary to protect federal public models. 20B is measures necessary to protect public health and the environment, and so on. These are fairly easy. I mean, you can. 20D are measures that are necessary to secure compliance with domestic law or regulations, or I should say, text says, with laws and regulations that are themselves WTO, particularly GATT consistent. So you have GATT consistent domestic legislation. In order to ensure compliance with that GATT consistent domestic legislation, you need to do something that is not GATT consistent. You need to take a measure that is not GATT consistent. Under Article 20D, you can do that. Let me give you a simple example. You all know about intellectual property. Now, there are products that are being produced in violation of patent rights. So they're violation of trademarks. They're fake products. They're products that are in violation of intellectual property rights. Now, if these products are then being imported, attempted to be imported, suppose they will be stopped at the border, and the customs officials say, well, no, this is a product that has been produced in violation with an intellectual property right, and they stop product. That's in itself is an import ban. An import ban is a violation of Article 11, but you can justify the stopping of the importation on the basis of Article 20D, because the stopping at the border, this import ban of fake products, is justified because it is necessary to secure compliance with domestic intellectual property law. Right? So This is another example out of a different context, but it's the easiest way to understand what this Article 20D is all about. Now, Article 20D is there to secure compliance with laws and regulations. That's what the text says. What does India do? India comes with the argument that its measure is necessary to secure compliance with international instruments. And they referred, for example, to something that we discussed also yesterday, the United Nations Framework Convention on Climate Change. They also referred to the 1992 RIA Declaration, and it's ... There are 2 or 3 others that they referred to. Question that panel, and at this point the appellate body had to respond to was, well, are these international instruments, are they laws and regulations as referred to in Article 20D? It has always been understood that we were talking about domestic laws and regulations. But India now makes the argument, no. Also, these international instruments have to be considered. What India failed to show is that the international instruments had direct effect and were part of the Indian domestic legal order. That's what the panel said. India, you failed to show that. With regard to India, did not only fall back on domestic instruments, it also invoked a number of, not only fell back on international instruments, it also invoked a number of domestic instruments. But there the panel said that these domestic instruments must be laws or regulations that are legally enforceable, rules of conduct in the domestic legal order. So the emphasis here is on legally enforceable rules. What India had invoked was Section 3 of the Electricity Act, the National Electric Policy, perhaps there's a typo there, National Electricity Plan, the National Action Plan on Climate Change. These were the domestic instruments that India invoked. Of those domestic instruments, the panel found that only Section 3 of the Electricity Act provided for legally enforceable rules of conduct. The others were policy statements, were, declarations, plans, useful, necessary, but they did not provide for legally enforceable rules. But then, subsequently, with regard to that Section 3 of the Electricity Act, India said that, the panel said that India failed to show that measure at issue, or the domestic content requirement, was a measure that was necessary to ensure compliance with the Electricity Act. So in order to comply with Section 3 of the Electricity Act, it was not necessary, or at least India didn't show that it was necessary, to have the domestic content requirement. That's what the panel found. Yes?
have argued that it needs to conserve its exhaustible natural resources because the majority of electricity produced in India is either coal generated or by any unthermal means like natural gas.
But they didn't.
But
They did not. They did not invoke Article 20J.
Would be in a better off position if added this particular exception.
Excuse me.
But didn't India be in a better off position with Article 20J?
Let's think through that. Yeah. If they would have invoked Article 20J, Germany, yeah, G. If they would have invoked Article 20G, what would they have been required to do? They would have to try to show that the measure at issue relates to the conservation of an exhaustible natural resource and is adopted in conjunction with domestic measures to conserve that same exhaustible natural resource. Excuse me?
What would be an exhaustible natural? We know US gasoline, clean air, US shrimp turtle. So in this case,
that's indeed the first question that then arises. What is the exhaustible natural resource here? I think if we go back in, go further in time, the exhaustible natural resource could be. We're not going to talk about that because we will focus on the TBT aspects of the EU palm oil case, but in the EU palm oil case, Article 20J was invoked. And the climate was considered in that case to be an exhaustible natural resource. But that's later. I think the reason why India did not invoke Article 20J because they were not certain what the exhaustible natural resource would be. It's true in the very first case that went to the appellate body, US gasoline case, clean air was already defined as an exhaustible natural resource. But is this a question of clean air? Perhaps it is. Perhaps you can expand it that way. But whatever the reason is, don't ask me. You're not asking me the reasons why they didn't involve it. You ask me, would they have been successful? More successful? Actually, everybody was a bit surprised when they saw the invocation of Article 20G, because this was the very, very, very first time that this was done. This provision had never been invoked before. Would have been more successful on the J? Don't know. But perhaps, what's your take on this?
When I was taught this case in 2013, the first thing my professor, Professor Jay Govind, discussed this case to me, we don't just discuss the facts and the report. He starts the discussion by saying what India could have done, like how India did not put forth its best argument in defending the matter. So that's how, it's ingrained in my idea about 3A. So we could have built around the defense of Article 3A and the logic of, this is immediate requirement for the product that was generated. So G20G probably could have been the same reason. Like at that point of time, there was no clarity as to what could be covered. So the only thing that we know was exhaustible natural resource, clean air, and turtle migratory nature, it, crosses and all of that. There were big justification was given. So now with the palm oil case, probably climate could have.
Well, let's not forget that even if you would have survived test of 20G or 20J or 20D, you still have the chapeau. Yeah? And under the chapeau, you would have to show that the way in which the measure was implemented does not constitute arbitrary or justifiable discrimination. But at least 20G would have had the advantage of not having a necessity or an essential test. Yeah, only a relating to test. Yes, I mean, no, the questions, ask, well, yeah, I don't know whom you would ask, why you have an idea.
So there are some scholars written on this point. Argues that they could have used Article 20B also for a justification.
Again, correct. And actually that's what you see the European Union doing. We won't discuss that in class, but that's what you see them do in the EU palm oil case. They invoke A, 20A, 20B, and 20D. No, sorry. A, yes, A, B, D, and G. So, what did the appellate body do? Issues on appeal were again limited. I mean, not everything was appealed. Yeah, and we're not even looking at all the issues. We're looking at the most central issues. First of all, whether the measure at issue was covered by Article 38A of the GATT. That's the first one. Issue on appeal, and the second issue on appeal is whether the measure was justified under Article 20. Now, on Article 38A of the GATT, the government procurement exception, the appellate body had an easy task. The panel actually followed the appellate body case law to the letter. So we're upholding the panel. On the exceptions under Article 20, the discussion was a little bit different. And whereas the panel had given its reasons to disagree with the invocation of Article 20, the appellate body slightly modified findings of the panel. First of all, it agreed with the panel that the lack of manufacturing capacity of solar cells and modules, that is not a situation of general or local short supply. And it is not a situation of short supply because you do have to take into account imports. But, and this is a qualification of what the panel found, it did recognize that there may be situations in which these imports or the availability of imports is theoretical rather than practical than real. And they tried to say that by the following. The quantity of imports that may be available must be considered in assessing a situation of short supply. So if, yes, theoretically, there can be all sorts of imports from anywhere in the world, but you have to assess the quantity of imports that may be available in order to come to the conclusion that there is a short supply. And I think this is a modification on what the panel said. The panel was more sharp, more definitive. Although they did add this idea of imminent risk. But the appellate body went further in taking into account that imports may not be available, may be theoretical. We have a very interesting discussion going on the last row. Please feel free to share your ideas and thoughts with us all. No, okay, fine. Now, with regard to 20, so this part of the Article 20 has not been successfully invoked, also according to the appellate body. Then with regard to Article 20D, again, the appellate body agreed with the panel that Article 20D was not available as a justification, but for slightly different reasons. First of all, with regard to the domestic industry, the domestic instruments that were invoked, the appellate body said that these were not laws or regulations within the meaning of Article 20D, because they do not operate with sufficient degree of normativity, so as to set out a rule of conduct or course of action. And with that, it has actually now laid down what in the future will be required of domestic instruments. They really have to be instruments with sufficient degree of normativity, instruments that set out a rule of conduct or course of action. And that was not the case with the domestic industries that were invoked. With regard to the international instruments, the appellate body said, no, these were not. For example, the UN Framework Convention on Climate Change, that was not a law or regulation, because India failed to show that these instruments had direct effect in its domestic legal order. I remember that India, during the hearing made before the division, the argument that, well, but there is no longer any need for parliamentary involvement in enacting domestic legislation. When India has concluded an international agreement, that international agreement has been ratified, the government can then, without involvement of parliament, take implementing action. That's how I understood their argument. But that's actually saying, and they use that argument as saying, so the international agreement has direct effect, is part of the domestic legal order. But actually the argument that they made contradicted this, because you do need governmental action to implement the international agreement. The fact that the parliament no longer is involved, neither here nor there. And does not make an international agreement directly applicable in your domestic legal order. So it was a good attempt to show that there was, but we digged into books of Indian constitutional law, and we were fortunate at the time to have two Indians as part of our secretariat. So they did overtime, looking at all possible arguments. But no, so there was still governmental involvement in implementing whatever was required under these international instruments. So no direct effect. These instruments were not part of the domestic legal order. Are there WTO members in which this is the case? Yes, there are. There are, among WTO members, there are some monist countries. Mexico is one of them. In Mexico, an international agreement is directly part of the domestic legal order and can be invoked in court without any implementing legislation. So yes, it's not excluded, but it's rare. Please. You have to speak up because my hearing is not good.
Signing of an international agreement or a convention, we used to invoke Article 20A, that is the public morality exception, in the sense that the signing of a convention can be used to evince the morality of the population of a country.
Yes, it's totally different, huh? Because Article 20A was not invoked by India, but another possible argument that India could have made is that, and the European Union has been making that argument in later cases, actually in the case that we will discuss next, the EU palm oil case, but we won't talk about that aspect of the case. But yes, 20A, a measure necessary for the protection of public morals. What are a country's public morals? You will have to ask to look for evidence of that this is indeed part of your public moral concerns. The fact that you have signed and ratified an international agreement to prohibit child labor, an ILO convention, is an indication. It may not be sufficient, but it's an indication, it's an element in the argumentation that this is part of your public moral concerns. As your population sees that as a public moral concern, yes. Could one make this argument in India that the fight against climate change, fight against greenhouse gas emission, the promotion of green electricity, that is part of the public moral concern of the Indian? I wouldn't hesitate to make that argument. Yeah. Certainly, if you see what the European Union got away with in the EC seals products case.
But now that climate is considered to be an inexhaustible resource and all of that, so I think in future 20D can in 2025, with the consciousness for climate change that we have, should be invoked to justify countries like you mentioned in yesterday's lecture, national policy should be there for the climate friendly policies and all of that. So when countries adopt those policies, can they be justified in future under 20D? I mean, India couldn't do it. That's
I think one of the things that I'm trying to show with picking the three cases that I've now picked, and then we'll talk about cases that are pending or that are still coming tomorrow, is that there has been an evolution in this, yeah? And that we will see Article 20 being used in a more creative way. Yes, I mean, I think both under Article 20A, public morals, under Article 20B, the protection of the environment and public health. Under 20D, although having to overcome the difficulties that we are illustrating here, under 20G and under 20J, I think you will find arguments being made in the future. And as a respondent, you use everything possible under the sun. Okay. Now, with regard to the Indian solar cells case, and I said yesterday that I would not talk about this case, and I will not because I'm already over time with this lecture, is the US renewable energy case. Why is that an interesting case perhaps to talk about? Is because it was the retaliation of India when the United States brought the India solar cells case. India hit back by bringing the US renewable energy case. Now that's a case that focuses on a number of US states in the state measures that were there to promote renewable energy. India challenged this under Article 3.4. It's always been a bit of a mystery to me why they didn't challenge it more broadly, but they challenged it under 3.4. The United States had an incredibly weak defense. There was a finding of inconsistency by the panel, and the United States appealed into the void. Yeah. And that's where the case was until, of course, there was the big bromage between the United States and India, where they cleaned the slate, and all cases that they had against each other were forgotten and forgiven. Yeah? So then this one disappeared. That's actually also what happened in terms of the compliance with this case. Yeah? There was a mutually agreed solution reached, which basically said, oops, we'll forget about it, in July 2023. But before that, that's interesting, the United States complained about India not complying with the rules. So they started an Article 22 process in which they asked the BSB for the authorization to retaliate. Why to retaliate? Because India had not complied with the Appellate body report and the panel report in India solar cells. Almost immediately after that, after the US break, India responded to that to challenge the proposed level of retaliation, because the United States had asked for the sky and very, very high retaliation. India said, oh, no. This is not correct. Yeah? And at the same time, a bit later, same month, but a bit later, they introduced an Article 21.5 compliance procedure. They made, normally compliance procedures are started by the complainants. Complainants that says, hey, there has not been any compliance. But here, it was India that brought the compliance case by arguing that there had been sufficient compliance. All of that was lingering, was not much was done. And then we have the mutually agreed solution, which made this case basically disappear, but also this case disappear, and some others. Yeah. Where it's peace and quiet again between the United States and India. What is the policy space that is left for WTO members to address the climate crisis? Well, that's now the question that you should be struggling with. I think what we've learned from this is that the concept of short supply, that concept necessarily always involves imports. Yeah. And as the appellate body sees it, you have to, when you consider imports, you have to also take into account that the supply on that import side may not be reliable, the imports may not be available. You have to take that into account, which is something the panel didn't really do. That's one aspect. Under 20D, yeah, laws and regulations referred to in 20D are really domestic laws and regulations, not international obligations. Unless they are part of the domestic legal order, but that means that they have to have direct effect, and that's going to be true in very few countries. All right.